And with that, I'd just like to thank our panelists for being here today. I'm going to introduce each one of them real briefly so you all know who you're speaking to and asking questions of. And the first is Ed Zorn. He is CRMLS's Vice President and General Counsel. He is responsible for all legal things CRMLS, and part of his role is to oversee the compliance and data licensing departments. And he's served as an attorney in real estate law representing associations and brokerages, and also has 20 years as a practicing broker and has owned his own independent brokerage. Jeff Smetana, and I hope I did that right, Smetana is Director of Compliance and Data Licensing at CRMLS, and he's also Assistant General Counsel. And Jeff has always also worked as a practicing real estate professional, which I think really gives both of them such an insight into our business, obviously. And Megan Barber is the compliance manager at CRMLS, and she leads a dedicated staff of compliance analysts who receive over 3,000 monthly compliance reports. And that is the way we keep our data clean, and it's important. So that's one of the reasons why we're all here today. So with that, what I'd like to start off with is Megan gave us the top 3 questions that we hear in compliance. So I'd like you to all use your reactions tab and give me an answer. Is this yes, true, or no, false? With clear cooperations, listings are no longer able to be excluded. Is that a yes or a no? So just throw your answer out there if you would. I don't see a lot of people. I see one person throwing out a no, and that would be the answer. It is false. So I'd like you guys to speak a little bit to the exclusion piece if you can.
Jeff, you want to handle that one?
Sure. Well, good afternoon, everybody. It's good to see you from a virtual distance. Let me adjust this camera. So the idea of excluding a listing has been around for a long time, right? So you join an MLS, and one of the primary core agreements that you make is that by joining, you're going to agree to put your listings in, right? For everybody else to see them and sell them. And you get the benefit of everybody else saying the same thing to you, making the same commitment. Even so, for many, many years, the idea of getting a waiver or an exclusion has been around. Prior to clear cooperation, the context of excluding a listing meant that you could do whatever you wanted with it, right? You could market it publicly and go your way, and that was it. You still can exclude a listing. You are still not 100% obligated to put your listings in the MLS. That option is still available to you and your sellers. The difference now, well, for over a year now, is if you do exclude, you've got the public marketing issue to contend with, right? So if you do publicly market, it's going to trigger the rule that says you then have to put it into the MLS for cooperation within 1 business day. So you can exclude a listing. There are new conditions on doing so. The big one being, if you're going to exclude it, you can't market to the public, which I believe we're going to talk about what that means in depth. So yes, you can still exclude a listing if that's what your seller wants.
Very well explained. Thank you so much, Jeff, because that really helps a lot. I mean, I think it just dials it down. And I would like each and every one of you who are listening today, if you have a question, please feel free to either raise your hand or stick it in the chat, because I want to get your questions answered. This is really about how we handle it day to day in the field and what we do with our clients. And it's really important that if you have a question, you put it forward. So these are questions that came to us prior to that for the registrants. And so I'm going to read some of them as we go along. Well, this is kind of I think we kind of just answered that. So I'm going to move on. For an exclusive listing, who is considered a client that we can speak to about it?
I'll take that one as well. So let's put it in context, right? So we're jumping ahead to what constitutes public marketing and who is the public, right? Because if we go back to the rule, the core of the rule says, if you market a listing that's not on the MLS yet, and you market it to someone who is considered the public, then it triggers the rule, right? So then we get into the idea of, well, then who is not the public? That's really what you're asking. right? Who can I talk to about this? At CRMLS, well, so NAR put the policy out and didn't actually come up with a definition, right, of who is and who isn't the public. So we, the MLSs were left to do that on our own. And what we came up with is what we'd like to consider a bright line rule. There's not a lot of gray area in it. It's basically the way we define someone being excluded from the definition of the public is if they have signed the agency disclosure form with your brokerage within the last year. What does that mean? It means they're sort of beyond someone that is just a prospect, right? They're not just someone that's been on your email list for the last 10 years or someone that you did a deal with 6 years ago and you're sending them postcards at Christmas. These are folks that you're working with, you have an active working relationship with, and the likelihood that you're going to try to get into a transaction or get into a transaction is very real, right? It's not just a prospecting issue. This is what we hesitate to use the term client, but we kind of would want to call them maybe the customer, right? You've got a prospect and a customer. So by using the agency disclosure form, if that person has signed that with your brokerage in the year, we do not consider them the public. So you can talk to those folks and not violate or trigger the clear cooperation policy rule.
Okay, that's very clear. So an AD signed within the last year.
Correct.
So if that's the case, let's say I speak to a client, I have a client that's been on my email list forever and ever and ever. Do I say to them, hey, sign this agency disclosure and then we can talk about some things that we have that might fit your needs? Is that what you're suggesting?
That's what you're suggesting, and I would say that's a reasonable suggestion.
Okay, fair enough. Fair enough. A lawyer speak.
Ed wants to say something, though. I can tell.
Yeah, I think I want to get kind of a little bit behind the philosophy of what this is. If you look at NAR, right, the National Association of Realtors, and that's the entity that created this rule. Remember, this isn't a CRMLS creation. This is something that was implemented across the country. It actually had been wrestled with for about 3 years and was the #1 topic as far as what to do with these off MLS listings that was in front of the Emerging Issues Task Force or Advisory Board, excuse me, which then reports directly to the NAR MLS Policy Committee. And if you look at the NAR frequently asked questions, they use the phrase client a whole lot in who's not a member of the public. Philosophically, the reason that exists is we understand that in ordinary brokerage relationships, communicating to your own client, someone you're actively working with right now, is not marketing. I never market or advertise to my client. I communicate with them. I send emails to them. They're my client, right? I advertise and I market to get a client, right? To obtain someone to work with me. And so that was an important distinction. And what we did at CRMLS, as Jeff really succinctly put it, so as not to trigger a higher level of fiduciary duty, which triggers with clients, meaning you should be signing buyer broker agreements under Article 9 of the Code of Ethics, right? We thought taking one slight step back from that and dealing with the agency disclosure would make more sense. Keeping in mind, again, under California law, your obligation to sign the agency disclosure is at the, quote, earliest opportunity possible. That's what the law says. It's not signing an AD 2 seconds before you fill out the purchase agreement when you've been working with these clients for the last 3 months, right? The code says at the earliest opportunity possible. So if your relationship is developed sufficiently to the point where you're doing an agency disclosure form, then we feel that's the kind of relationship that NAR intended to be, not a member of the public. And there's more communication and more interaction going on.
And to be clear, that is CRMLS's definition of a customer, is that the AD has been signed within the last year.
Correct. That's our definition of what keeps somebody from being a member of the public and triggering the clear cooperation policy. It would be, that brokerage firm has a agency disclosure signed within the last year. Very objective, very simple. Either you have it or you don't. Not a lot of debate going on.
Yeah, and it is written explicitly in that manner in our rule set. It was not in the policy 8.0 that was issued by NAR. We took it and clarified within our particular rule.
And I make note of that because some of our members have dual membership in other MLSs. So that is the rule with CRMLS. So for a coming soon listing, am I able to show other agents such as those who are in my office?
No. So for a coming soon listing, you can't show anybody.
Including yourself, I presume.
Well, I mean.
Well, your own clients, I'm sorry.
Yes, correct. Listing broker, buyer's agents, doesn't matter. No showings in coming soon. And I want to backtrack a little bit and point to where I think this blurring of the lines comes from, right? So you talk about CCP and then you talk about coming soon. And these were concepts that, from our perspective, were introduced fairly closely together. We did a lot of presentations where we were talking about all of these things together in one big conversation. And so the lines began to blur and people's eyes began to cross, and the concepts were flying around and they couldn't distinguish them. But the most important thing you need to understand, and the best, cleanest way to distinguish CCP from coming soon is CCP and the attendant rules and issues only apply to listings that are not in the MLS yet. So anything that falls under CCP, like who is the public and what is marketing and who can I show it to, that only relates to listings that are not in the MLS. A coming soon listing is in the MLS, okay? So all of those concepts at CCP should just sort of be pushed to the side when you're thinking about coming soon. Coming soon is a unique status in the MLS with its own set of behaviors and things you can do and can't do with it, right? And one thing is you can't show it to anybody. Don't think about who's the public. Don't think about who isn't the public. Don't think about, is this marketing? Can I put a sign in front of my coming soon? I get that a lot in my presentations, and I'm really trying to undo some of that confusion that's sort of followed us to this point. Really, really important to think of a coming soon listing as I'll say it this way, and maybe other folks don't love this, but it's just like an active listing that you can't show.
That's it.
Right? And if you just stick with that, there are subtle other little tricks and things regarding coming soon, but it behaves just like an active listing, but you can't show it, right? At least when it's in that coming soon status. So we really got to kind of separate all of these issues that fly around when we're having these big conversations. You can't show it to anybody. You can't. It's just, that's a unique issue with coming soon.
I think I would phrase it just slightly different, and that is a coming soon listing is an active that you have promised and that you, the listing agent, have represented to everybody else that you will not show. So it's not that you can't show it. You've decided you will not show it. That's why you decided to put in coming soon instead of active. That was your choice.
So can we maybe back up and give a history, because I think, Jeff, you make a very good point about the CCP is the before it hits the MLS. And then once it hits the MLS, CCP is really not necessary because it's in the MLS. So the history of coming soon with CRMLS, this was kind of, if I'm not mistaken, the way of addressing a lot of members' concerns about getting it into the MLS. So this is not something that, CRMLS created to, except this was something that was created because of CCP, am I correct?
So not entirely, and I can address that one. Okay. CRMLS in the coming soon issue had been around for a long time before the clear cooperation policy. I know most of the members here were not part of CRMLS back in the pre-CCP days, but back in those days, we had an exclusion process where you could modify days on market based on whether or not you were actively marketing or not marketing the property. And that worked very well. And as a result, we had no coming soon status. We had no need for a coming soon status. The way our rule worked before the clear cooperation policy was if you excluded the listing and it was off the MLS and you decided to market it, we would count the days on market. So you would show it and do everything you wanted. If you decided not to market the property because it wasn't ready to be shown, you didn't want anyone to know about it, then we would not count the days on market against you. Then when the clear cooperation policy got passed by NAR, and in the rules committee, I can tell you the first probably 3 rule committee meetings that occurred with regard to the development of the clear cooperation policy rule did not anticipate or consider at all having coming soon. It was debated and shot down each time. Then when we got to basically February or March of 2020, when we really had to, and May was our trigger date, we heard a lot from the brokerage community as we sent our rules around for comment. And there was a big outpouring of a desire to have a formalized coming soon process. And so it was at that point that was presented to the board of directors. And after a lot of debate, the board of directors decided to go ahead and have a coming soon with these specific rules surrounding it that kind of, if you will, mimicked a bit what we were doing with our exclusion process beforehand. So coming soon is here because the brokerage community expressed a high level of interest in having it. It's kind of interesting now, I'll be honest with you, there are a number of MLSs, the largest one in Ohio being the most recent, that have just dumped their coming soon. They've just completely eliminated under the concept that it's more confusing, more problematic, and creates more liability than it's worth. So we're actually starting to see around the country a kind of ending of the coming soon shtick.
Okay. With that, the number 2 question that Megan brought forward, so Megan, I'll let you answer this question, is days on market does not accumulate in coming soon status, true or false?
Do you want people to vote on that first before I answer?
Yeah.
Okay.
So what does the consensus think? Days on market does not accumulate in coming soon, true or false? Let's see, I've got some trues popping through. So is it true? Our consensus is true.
That's correct. Yeah, so as long as it's in the status of coming soon, there are no days on market accumulating. We did have a rule change or an addition actually to the rule set that allows us to modify the days on market if we do see that there was public marketing prior to you entering the listing into the MLS. But other than that, if you enter it, there's truly no marketing prior to being entered as coming soon. As long as it's in that status, there will be 0 days on market.
Okay, great. Looks like most of us most were in agreement and knew that to be the case. I think this gets really confusing, so it's nice to have that reminder. Yeah.
It's Wendy here. Can we back up? I apologize. I did not see Tracy's question in the chat. We're going to go back to the exclusion conversation. The question is, if we have an excluded listing, can we still enter it into the MLS once we have it in escrow as active/contingent to contribute to the MLS data?
So why don't I take that one? That's going to be some contractual issues going on there. Certainly when it closes escrow, you can put it into the MLS because I believe it's on paragraph 24 under the current RPA. Both the buyer and the seller give permission for the brokers to report the listing as a closed sale. That's already your right in the RPA. So as long as that paragraph hasn't been changed, you can put a closed sale in. The problem you have with a active under contract going into the MLS is you're in possession of an instruction on an excluded listing that specifically demands from your client, the seller, to not place it into the MLS for cooperation. If you put it under active contingent in other words, searching for backup offers, by rule, you are offering compensation and cooperation by that being in that particular status. So while the computer will let you do it, you are probably violating the contract between you and the seller if you truly have an excluded listing. Now, you can end the exclusion by simply getting an instruction from your client, the seller, that says, I instruct you to put the listing into the multiple listing service. I withdraw my exclusion, right? Talk to your broker or lawyer as to what the proper mechanism would be for withdrawing the exclusion. And then, yes, then you could go ahead and put it in, in an active contingent kind of status. But without that removing the exclusion instruction from your seller, you could be violating your contract with the seller.
Not to mention that what happens if it falls out of escrow, right? Then you're going to go ahead and put it into active status. Is that what your seller wanted when they asked you to exclude it? We certainly appreciate the idea of people wanting to contribute to the MLS data. We want your comps, 100%. But Ed's trying.
We want your listing.
Yeah, Ed's trying to help. Kind of, you don't want to get yourself in a sticky situation with your seller. Like, uh-oh, what do I do now, right?
Well, great question. And also, I got a private note that's just to remind everybody that when we're talking about CCP, we are talking about the clear cooperation rule that was set by NAR, Rule 8.0, some refer to it as, that basically says every listing needs to be a cooperative listing if we're publicly marketing it. Okay. Since the coming soon status can only be used once for a listing, am I able to get it corrected if I inadvertently put it to active rather than coming soon at the beginning?
That's for you, Megan.
Yeah, we're going to let you take the technical ones, Megan.
Okay. So there is no way, even with us having admin level or admin rights or permissions to the MLS, there's no way for us to change the listing into coming soon from an active status. If you accidentally enter the listing as active instead of coming soon, immediately contact our compliance department. You can contact us via chat or by email. The sooner the better in these types of situations. So just definitely reach out to us and we will give you instructions on what to do. But if you let it go for about a week or 2 weeks and then you realize, oh, it should have been incoming soon, there's not much we can do at that point. So the best thing is just to reach out to us as soon as possible, but just keep in mind that if you are incoming soon, let's say you do enter it correctly and you hit the change to active button, we can't do anything at that point either. So as soon as it goes from coming soon to active, or if you enter it as active by mistake and don't do anything with it, there's not much we can do to make it go back to that coming soon status.
Because there's a lot of interconnected data related to that, right? So once it goes to active, it starts counting days on market, right? And then that's being transmitted out. And were we to go in and tamper with that and erase it, believe me, the agents out there are going to know when we get these reports, hey, this had 3 days on market, now it's back down to 0. What the heck is going on? What did you guys do? Right? From the perspective of the agent who made the mistake, who cares, right? I made a mistake and I got my DOM wiped away. But from a data accuracy standpoint and even a public perception standpoint, we really want to avoid those kinds of situations.
So 2 things I have to say on that. One is DOM that Jeff just mentioned is days on market, just for clarity's purposes. And also I will say, Megan, we had an agent in our office inadvertently put something active instead of coming soon and had the paperwork in, which is my next question. But your staff was very helpful. She got it, called in within 24 hours and it was rectified. So they do a really great job of trying to help you, but be mindful that when you are putting a listing in, it's going to go to active unless you select coming soon. So make sure if you're going in there to put it in as coming soon, you select the coming soon option. And also when you do put it as coming soon, there will be a select a showing date. That's the date that it would be, and when that showing date is the date it's actually going to go active. So it automatically will roll to active at midnight, 12:01 a.m. on that date. So if you are unsure, make sure that you put it out the 21 days, and then you can go in and change it and make it sooner. But you don't want to say it's going to go active for showings in 2 days when you're not 100% sure of that, because it will automatically roll at 12:01 a.m.
That's a great point, Carolyn, but let me add another thing. Remember, you have a contract with a seller, and that contract with the seller, probably in paragraph 7 of your RLA, has that date in it as to when it's going to go showing. So if you move that date forward or back, I would strongly recommend that you make sure you have some kind of writing, an email, something to document this. Remember, these are the seller's listings and the seller's decisions to document that. Because if we get a report, that's what we're going to ask you for. And we're going to want to see that what happened in the MLS matches your contract status, right? That's how we make sure the data is accurate. So no problem in doing what Carolyn just described. Just make sure that if you do modify those days, you also get that instruction from your client.
Absolutely. I mean, follow the contract. And one piece of contract paperwork that is not in our contract necessarily, but is a CRMLS form, is the coming soon form. Can someone speak to that, of what is required and how it is required? Because if I'm not mistaken, Ed, the date in the contract is the public marketing date.
That's true. You're right. I did misspeak. It is the public marketing date, but the form has the start showing date on it, which is what you're supposed to be following. So it would be the form that we would gather to make sure. And again, you can modify the information on that. We just want to make sure it's the seller that's making these decisions of what's happening with their property. And that's, again, what we look for when we do an investigation.
So what you're referring to is the coming soon form that's on the CRMLS dashboard. So there is a contract, but if we are going to put it into coming soon, CRMLS is requiring that coming soon form that speaks to those dates you're talking about.
Correct.
Okay.
To be clear, we're not requiring that you send it to us. We only require that you have it. Right? We're
So
not,
that if you ask for it, we
yes,
can apply it in a timely fashion.
yeah. And it's created because the status definition in Rule 10.2 of a coming soon says specifically that the broker is in possession of a seller instruction to use coming soon status. Why is that important? Because we want the seller to understand. We trust you guys, but we want to help you, help them understand what they can and can't do and what it means for them to use coming soon. Otherwise, they're going to run wild with whatever they think they can and can't do, right? So it's a very clarifying form, very helpful. It protects you, right? Because you don't want your seller, for instance, holding their own open house while it's in coming soon. Or, saying, hey, I just decided I'm going to show this house. That's going to be your responsibility. I know there are questions about that, but it's a good form. It's helpful. It's on our dashboard. It's also in zip forms. So something you need to have in possession. We won't ask you for it unless there's a real question about it.
Yeah, and I really am grateful for that form, because then it doesn't come back on me. I have it in writing when these dates start, when I'm putting it into coming soon, when we plan on start showing it, and I just do a modification if we're going to change dates. So those are really, it helps me have the background so that it's not my decision, it's my client's decision. Obviously with your tutelage, but as you go through that process. So thank you for those. All right, here's a doozy. At an office meeting, brokers, agents are often called to share about office exclusives in those meetings. But there are often affiliates present at those meetings who are not brokerage employees. Does this constitute a breach of MLS policy?
The answer is not necessarily. Okay, so you got to be careful But what we don't want you guys to think is that anytime you talk about your listing, it's marketing, right? Because it's public marketing that triggers the clear cooperation rule. What is marketing, right? It's efforts that you make to solicit interest in the property that you're going to list or that you are listing. Are you trying to solicit those affiliates at the meeting? Probably not. They're there to help you and, bring forth, whatever special offers and things that they can do for your brokerage. So I think necessarily no. Case by case though, guys, right? So what if, that particular affiliate comes up to that agent who has this, hey, soon coming to the market kind of a listing that you guys talk about, and says, hey, that sounds great. I'm so excited I'm here that I got to hear about this. Let's talk, right? Am I ever going to know those details in an investigation? Maybe, maybe not. I don't know. But if that's what happens, I think we all could agree that you engaged in marketing at that point. But the title rep who comes to your brokerage to bring donuts and just gets to hear everything is not necessarily being marketed to. Make sense?
And another key, dovetailing on exactly what Jeff is saying, what we don't want to see is that title rep or that mortgage professional that you guys refer to then has inside their drawer, their little secret exclusive list. So when they're qualifying someone for a mortgage, hey, here are these 6 properties I know are not really out there yet. Why don't we, make a call on these, right? Again, that would be a violation by there being taking another step. So you're going to be responsible for those individuals that are in that meeting to make sure they don't take the information they gathered from that meeting and themselves start marketing, right? You're still going to be responsible for any marketing that comes out, from them participating, but them being in the room, it is not in and of itself a violation.
So
How do you, oh, go ahead.
So it kind of relates to that question, the chat that BJ just put in there, and it's they can't control what they do with that information. Would you recommend that at those private office broker where there is a sponsor or whatever, that maybe they start the meeting to remind everybody that, what happens in this meeting stays in this meeting kind of thing?
Well, I would assume that if you're close enough to be inviting affiliates into a sales meeting, you have some level of a relationship with these individuals. I'm assuming they just didn't happen to, stumble into the office at 8 o'clock by accident. And certainly I would suggest that as a broker, I can't control what that affiliate does, right? If you're going to participate in this meeting and you're going to listen to this sales meeting and be given an opportunity to talk to my agents, you're going to follow my rules. And if my rule is you don't share, you don't write down, you don't take the information about exclusive properties that we're sharing out of this room, and you can't abide by that rule, you're not going to be invited to come back.
If I was your lawyer, and Ed would probably agree with this, I'd probably have a form that they're going to sign before they are invited or able to attend the meeting. I know that's a hassle, but as lawyers, we would probably love to have, an informed consent / waiver from somebody like that. Not saying that's what you need to do, but if you want to know how to really protect yourself, that's always an option.
So let me throw this out at you, because here's something. You have a fiduciary to your client, right, to sell their house. I'm in a meeting, and I'm trying to throw a wrench into it a little bit, but we're in a meeting. I'm going to pitch my listing, and I pitch the listing, and afterwards the title rep comes up and says, oh, my mom has been looking for something just like that. Now I have a fiduciary to my client to sell the house, right? And I also have this situation. How do we handle that situation?
Again, those are very case by case, super ultra specific scenarios. The question at that point is, did you engage in marketing? That's a tight call. Probably not, because that wasn't your intent. Yeah. So I would say your best bet would be to get an agency disclosure form signed, or your other option would be within 1 business day, put the property into the MLS. Okay. Remember, that's always the safety valve, right? If you're ready to pitch a listing and this person's ready to put an offer in, It sounds to me like that property's ready. Why don't we get that into the MLS as an active listing and let's go? Why are we holding it?
Okay. And if it's, I mean, and I think that if it's getting painted or what have you, you set that up in a different way to, so that it's still compliant, either within 1 business day, the agency disclosure, or, you know, we put it back on, or they wait 2 weeks until it's active, right?
Or you can
Correct.
wait 3, you can put in a coming soon and you have 3 weeks.
There you go.
Right.
There you go.
Right. And then they're going to have to wait to see it like everybody else. Right. The concept here is that it's a level playing field.
You know,
Okay.
once it's in coming soon, you can certainly talk to that person. Again, the
Yeah.
public marketing issue goes away. Just can't show it to them. That's all.
Right.
Yeah.
Lots of options.
Okay. How does CRMLS handle coming soon listings for listings that are not within their service area?
So I'll take this one. So remember, the CRMLS service area is by county. So, right, Los Angeles County, Ventura County are in our service area. The rules for a CRMLS agent belong to the CRMLS agent. So now let's talk about Santa Barbara, right? Santa Barbara County is not in our service area. And so we don't have any jurisdiction with regard to listings in. You're not required to put those listings from Santa Barbara into CRMLS. So let's say you're a member of Santa Barbara, right, and CRMLS. You can put the listing only in Santa Barbara, and then you're going to need to follow the Santa Barbara rules, you know, with regard to that listing, but you do not have an obligation to also put that listing into CRMLS.
And if you put it in, so you're following the Santa Barbara rules in that instance.
Right. Now, let's go to the next step. Let's say you want to put the Santa Barbara County listing into CRMLS, which you have a right to do. Service area only dictates to what's mandatory for you to submit. But you can submit properties anywhere in the state. Even if it's not in our service area, you still have the option to put it in CRMLS. Now, if you're going to put that Santa Barbara listing into CRMLS, you're going to follow the CRMLS rules as it relates to that listing. So if you're going to put that in as coming soon, you may not show it. And if we get information that you showed it, you will get fined.
Okay. I think there's something that in the chat, but I'll let those guys look at that as we go along. Speaking of a neighboring MLS, one of them just changed their rules to allow agents to ask a direct question about a listing they think is coming up on the market. And they're allowing that agent to have the ability to answer that direct question. Has CRMLS discussed this type of rule change, or has any comments on answering a direct question? If somebody says, hey, my mother-in-law just told me that there's going to be, that you're taking a listing on her street and we're not ready for it. How do we deal with that direct question?
So first off, no, CRMLS is not engaging, and the rules committee doesn't spend a lot of active time on how to do an end run around CCP. We got a lot of other things to do. And so as Jeff and I and Megan have all talked about, there's very case-specific, case-relative information as you analyze, and not every case should deserve its own rule and exception and all of that. This is not hard to do. Again, it comes down to what Jeff has said over and over. It's marketing. What did marketing occur on the property? If it has, then it goes into the MLS either as coming soon or active. It's not hard. And so now when you start talking about a listing that's coming, so the first question is there an exclusive listing agreement signed? Because if there's no exclusive listing agreement signed, there are no rules at all. Right? So if I've talked to the person across the street about listing their home for the last 3 months, I have no rules attached to me. If I want to go out and talk to Megan, a friend of mine, that says, hey, the nice person across the street might want to maybe sell their house. I don't have a listing, but let's go see if we can put a deal together. That's just ordinary brokerage work. And none of our rules prohibit you from engaging in any of that kind of activity. right? The rule triggers under the clear cooperation policy upon the execution of a exclusive listing agreement, right? Same rule for an open listing agreement, right? If you handle high-end clients, I happen to have a listing for a Major League Baseball player, and at the time he became the MVP of the league, right? And there were NDAs, there were trusts, there were all kinds of mechanisms in place to protect that privacy. And one of the things you could do also is take an open listing for which the rules don't apply. Our rules only apply for an exclusive listing. So if you have one of these high-end clients and you want to talk to other people, other agents who maybe have other similarly situated clients, you can take an open listing. You can have those individuals sign NDAs or other ways to protect your interests and do whatever you want, right? The rule's very succinct, very specific, and honestly, very easy to follow.
Great. Really appreciate that. I think that was a pretty cut and dry answer to that. With that in mind, what you're saying then in terms of a coming soon, just a point of clarification that came up the other day, is that means no previewing either. So the only people that can go into that listing are people who are preparing that listing for the active status. So photographer or, you know, a repair person, but you are not allowing anyone in your office or anyone out of your office. It's another agent to see that listing at that particular point in time.
Yeah, I mean, because look, guys, what is an agent? It's someone who acts in the capacity on behalf of a principal. So an agent going in and previewing a property under the law in many respects is no different than the client going in and seeing it. So you're not going to be able to, you know, get around it because say, oh, well, I sent my agent. Well, that's basically admitting that you as much as saw it yourself, right? Legally speaking. So not a good distinction.
Great, thanks for that clarification. With neighboring, this is kind of more of a hot topic. With neighboring MLSs allowing different properties to be shown during coming soon statuses and different rule sets, what efforts are underway to provide consistent consumer experiences? CRMLS users have less options for sellers or increased expenses due to having to possibly join multiple MLSs.
So yeah, that's a great question. Honestly, a lot of effort. Art Carter, our CEO, to be honest, has been working on this probably for 4 or 5 months. There was an attempt at the CAR level, the California Association of Realtors, through their MLS committee, to put a task force together to explore better, more common rules. And frankly, it didn't work. They originally passed a set of rules or recommended a set of rules back in the winter meetings that were related to not showing a coming soon. Then that didn't pass through MLS policy committees, and the task force kind of remet and talked again. And there was a more soft pedaled recommendation that wasn't really much of anything. So when that was clear that that wasn't going to result in any meaningful consensus, Art started going out and talking with the other MLSs directly in an effort to put together a meeting to at least see if all of the neighboring MLSs to CRMLS could agree to some common set of coming soon rules, specifically as it relates to showings. We've had some progress on that. There have been some talks that have already occurred, and I believe there's another meeting scheduled in the next few weeks on this exact topic. So we continue in an effort to get some consensus. I can tell you in all of the meetings that CRMLS participates in, for us, showing a coming soon listing is not on the table to negotiate. I have spoken on this subject at a national level probably 3 or 4 times through different NAR and the Council Multiple Listing Service conferences. And in the surveys that have been done across the country, I believe we're less than 13% of all MLSs, there's 500 of them, would allow a showing on a coming soon listing. And the majority of those that do actually do count days on market for their coming soon. So there are a tiny handful of MLSs that allow showings of a coming soon, but don't count days on market. And the reason it's a tiny handful is a very, very strong argument can be made that not counting days on market when you can market the property, show the property, and take an offer on a property is an intentional misrepresentation. That's a fancy lawyerly way of saying a fraud. And so there is some significant liability that would attach in engaging in a property where you're basically not telling the truth to a potential buyer about what the days on market. And then in my opinion, that liability attaches fully to a multiple listing service that does that. And so right now, realize we're in a position where what happens if a buyer overpays for a property? But they go to sleep and tomorrow it's not overpriced anymore, right? It went up over the course of the next week or the month, that we're okay. And so you're not going to see a lot of objection from buyers as the market's going like this. Anyone remember what it was like in 2007 and 2008 with regard to claims against brokers when the market did that? Right? Everybody who bought at the very top, what was the first thing they complained about when the market tipped down? Right? They went after their brokers. And I can tell you, I was involved in multiple cases as a lawyer and actually as an arbitrator back in that era. And I believe that's going to happen again. And one of the strongest arguments those buyers are going to have is I overpaid or I paid top property or premium for this home because I was told it was only 1 day or 2 days on market. But when I go back and look at the history, what happened is it was actually in this coming soon status with everybody showing it and offers being made for 20 days. But the listing agent and the MLS didn't tell me it was on the market, even though it was. How are we supposed to defend that position? And so I think that's the reason why very, very few MLSs would even consider allowing a showing of a coming soon. Like I said, some do, but most of those that do, again, would count days on market in coming soon. And so there you're being transparent and honest to the consumer. But no days on market on coming soon and showing it, I find that to be an indefensible position.
Very interesting stuff. Thank you for that. I think that was
Carolyn?
Yeah.
We have another question, and this question is one that I've gotten just several times this week alone, and that is, what about agents adding a coming soon listing and then it goes straight to pending? So we had a scenario where, well, this is the scenario I hear. Agents have a buyer and they're waiting, and it's still not available to go show them. And then a scenario of there's house cleaners or an inspector in the home, and someone drives by with their clients. Oh, can we just sneak in to take a peek? And maybe the listing agent isn't there, but then the very next morning, it's in pending. What do we do with those?
Yeah. Well, what you do is help us, right, by providing that evidence. Because what we're talking about here when we get these reports is what I believe and feel like happened versus what I can prove happened. Right? Remember, these kind of behaviors happen outside of the MLS. So my investigative team, all 20 plus of them, is no good to me unless I have some kind of evidence that this happened. Where am I going to get that evidence? Well, from my 100,000 compliance analysts who are out in the field, which are the agents, right? I know what this means to you. It means you might have to turn some of your colleagues in, and no one wants to do that. But for Megan and I and our team, we can't just act on the fact that we saw a listing that went straight from coming soon to pending or straight into pending status. Let's be clear. You can buy a property without seeing it. Right? It happens a lot. It's probably especially now. Contingent upon inspection or something like that. So Can someone put it in coming soon and go straight to pending, 20 minutes later because they got an offer, someone wants to buy the listing sight unseen? Yes, of course they can. Then they move it into pending status. Then the clients go in and see it because it's not a showing at that point, right? It's an inspection or something. So it's really tricky. We understand that this conduct is happening out there. It's the kind of market that breeds this kind of conduct, and it's unfortunate. But we would need some kind of evidence, and we investigate these pretty hard, right? We will get the lockbox readouts. We will get, testimony from that listing broker. We have the right and the capability to get testimony from the buyer's agent, and perhaps in some certain circumstances even ask the buyer themselves, because under the code of ethics and under our end user license agreement and our rule set, every agent who's one of our users is obligated to cooperate in an investigation. So what you're really asking us to do is whatever we can based upon the evidence we have, and we need to get that from you. So I don't know what that's going to look like, but we can't just make the presumption that it went from this status straight into a contract status to say, oh, guarantee that was shown. It might have been. That might be the most reasonable way to look at it. But I can't just issue a $2,500 citation, which is what goes, that's what you get when you show a coming soon. I can't just issue that without some hard evidence. So as infuriating as it might be in this really, really hot market, if you really have good evidence, send it to us, because we won't let it go. We won't let it go, but we don't have people standing at every open house, to make sure, or standing in front of every coming soon. So keep it in mind, that this is a self-policing industry, and I know you got to work with these people, but I will tell you that all reports to us are anonymous. Okay, so if it comes down to it and you really have some conduct that you want us to act upon, you can trust that we will keep your information, your reporting party information, confidential.
If I could answer a couple of questions in the chat that are directly on this point about the legality of, I think Jeff alluded to it. You can make an offer without it being shown, and that offer can be accepted. That's the choice between the buyer and the seller, and it does happen. Don't think it doesn't happen. And I say that very emphatically, having been an individual who's bought 2 properties sight unseen. Now, we did go to the property during the escrow period and done it, but I moved out of state, and the home I lived in, we had never seen. It was a hot market. We put an offer in probably 5 or 6 hours after it hit the market, because we knew the area, we knew exactly what we were looking for, had fantastic pictures that had a Matterport where I could walk through the house, which was a fantastic technology. And we put an offer in and it was accepted. And then we flew out and looked at it and went through the normal process. So people do, especially in a hot seller's market, they will absolutely put in an offer, sight unseen.
Okay. That actually was our third most asked question. Is it okay if a painter, handyman allows me into a coming soon listed by another agent in my office? Well, if it's coming soon, it is not allowed. Let me ask you this though. If a painter, as an agent, as a buyer's agent, I will say, let's say I'm, doing a drive-by, just saw a house coming soon. As a buyer's agent, I'm driving by slowly and I see the handyman out there and the garage door is open. If the handyman says, hey, come on in, you're welcome to say it, I'm here for the next hour, and I walk in, is that my error? Am I liable, or is the listing agent liable?
So if the listing agent reports you, which is what should happen, the handyman should tell the listing agent, hey, Carolyn came by, here's her card, I let her in the house. Hopefully the listing agent will report you for violating the showing instructions, right? So as a buyer's agent, you have a responsibility to not violate the published showing instructions in the multiple listing service. And on a coming soon listing, the showing instruction is what? No showing. So arguably, I would have no problem, Jeff, Megan, right? I believe we would immediately issue a violation to you as the buyer agent, right, for violating the obvious and clearly indicated showing instruction that the listing agent did. I mean, keep in mind, these are individuals' homes, right? You had an individual seller, a homeowner who said, I don't want anyone in my home until this date. What right do we as buyer agents have to override someone's who owns a property, right? As realtors, we always talk about defending private property rights. And this is a great example of a time where the private property right of a seller is at odds with what I want as a buyer's agent or what my client wants. I'm going to suggest to you as realtors who commit to the code of ethics, go back and read that preamble, right? It's our duty to protect private property rights first. And in my opinion, this gets to that issue, right? You have a seller who said, I want no one in my home until this date. We don't have a right as buyer agents to blow through that seller's instruction.
I would say that if you get reported and we were to issue a citation for failure to follow showing instructions, you'd be getting off cheap. Because
Yep.
that's a $1,500 citation versus the $2,500 citation for violating Rule 10 or 9.3, which is, and frankly, guys, I mean, we would, under those facts, we would get to choose. So, you know, Ed's being generous. With the attitude in the air of how upset people get about this, I think we might be better off issuing the bigger fine to prove the point. But thankfully, we're just talking about a hypothetical, right, everybody?
Indeed. Well, I will say a lot of people in the chat have really appreciated how cut and dry and clear cut your answer to that last question was, both of you, because it's truly based on what our homeowners are telling us. And if we violate that, then we're also in breach of our fiduciary to our clients, as well as the buyer, you know, as well as the fiduciary to our MLS agreements or our MLS rules. So with that, we are at 2:01, and I just, you know, I don't know if anybody has any additional questions to put forward. I've asked all of the questions that were presented earlier, with one exception, and that's more of a broader topic that is kind of a little off topic. So we'll hit that one on the next go round. But unless there's any other questions, I just really want to thank our panelists for giving us really down and dirty, straightforward answers and helping us understand this policy, both CCP policy as well as our coming soon status, and how to live by the rules in our new environment. And I really appreciate your time.
We thank you for the opportunity, and always ready to come back if you want to talk about other significant issues.
Yeah. Yeah, I commend you guys for attending this. It's
Yeah.
always good to see people who are interested in really knowing what's going on, you know, as opposed to just kind of thinking they know. So good job, everybody.
You're getting lots of thank yous and lots of love in the chat. So really, it was really this was really dialed down. So I really, really appreciate all your time. Thanks so much for everyone attending.
Take care, everybody.
Take care. Bye.
Thank you.
Thank you. See you guys.
Bye. See you soon.
Thanks, everyone.